Please be seated.
The next topic, Your Honours, is the meetings of the 22nd and 25th of August, dealt with by Mr. Thayer at 34076, where he deals with what he says is an incorrect citation in our brief at page 110. Could we concede that unfortunately in our brief we have mixed the two meetings up? As far as I could gather, Mr. Thayer had appreciated that because he in his submissions addressed each meeting in the correct manner. It's the meeting on the 22nd of August, which Guevara did not attend at Borriquay, which was variously regarded by Smith as, quote, fascinating, end quote, quote, a success, end quote, and, quote, a step in the right direction. Contrast that, we say, with the meeting on the 25th of August 1995, where Guevara didn't attend, and which Smith regarded as, quote, brief and businesslike, end quote. We next want to turn to paragraph 159 of the prosecution brief, where they deal with General Guevara's alleged monitoring of Spletcher 95. They say he monitored this operation by placing an assistant commander for morale at the forward command post. We contend that this shows a failure on the part of the prosecution to understand the strict reporting structure within the VRS, under which morale officers at the corps level did not and were not permitted to report directly to General Guevara's organ at the main staff level. This is dealt with in our final brief at pages 121, 123, which describes how matters worked. In short, the operations department would receive reports sent from the corps commander. The operations department would then separate out the issues pertaining to the remit of the sector of each of the assistant commanders in the main staff. General Guevara would only have received updates as to the morale situation within the Spritzer 95 operation through this channel. He would never have had any better insight into or influence over the operation resulting from a direct reporting line with the corps level morale officer who was ordered by Mladic to be embedded at the forward command post as set out in 5DP 2891. In short, a complete misconception of the evidence by the prosecution. Turning next to the issue of propaganda, yet again the allegation now made by the prosecution that Guevara was the chief propagandist of the VRS does not appear in the indictment. Indeed, the trial chamber are invited to contrast this with paragraph 74D1 in the indictment, where it said that Ptolemy is, quote, organised and led the psychological and propaganda activities related to the operations in Srebrenica and Jepa. We accept that in paragraph 277 of their pre-trial brief, the prosecution asserted, quote, Guevara was head of the department responsible for, end quote, inter alia, then open, quote again, psychological and propaganda-related activities. But that allegation does not appear anywhere in the indictment, and, as I've already said, it is levelled against Ptolemy in the way that I've described. The extent to which we say General Guevara had some responsibility for these matters, they're dealt with at our brief at pages 94 to 98. In paragraph 161 of the prosecution's brief, the prosecution have erroneously conflated the morale sector's information service, which was overseen by General Guerrero and produced Spurtska Vojska, and the Center for Information, Psychological and Propaganda Activities, which was headed by Milutinović and was directly subordinated to Mladić. These two units, we contend, were completely separate entities, and the latter was not overseen at all by our client and was instead directly subordinated to Mladić. Simic's evidence in regard to this is relied upon at page 113 of our brief. The prosecution make the same error in the second paragraph of 1750 of their brief. In support of their assertion there, they cite Takulia for this proposition at 15140, but in fact the witness only confirmed that General Guerrero was in charge of, quote, an information centre, end quote. He did not clarify which one or who it was headed by. In fact, when we were looking at this for a last time very recently, it became apparent that the proposition in the first sentence of paragraph 1750, where it says, another component of Guerrero's role as chief propagandist of the VRS was to remain attuned to how the VRS was perceived in the international media, looking for opportunity to present the VRS positively, as well as watching out for sources of negative portrayal, end quote. The prosecution only use a 1992 request of General Guerrero's as to the proper treatment of journalists at 6D129. And we say it's a quantum leap from the misleading proposition in the second sentence. It's an example of how one needs to read and analyse these prosecution assertions very carefully. In fact, they cite no evidence at all in support of their rather startling proposition that Guerrero's man was at the Hotel Fontana meeting. We ask rhetorically, has that ever been an issue in this case? Have they ever said that Guerrero had his man there at the Hotel Fontana? Of course not. Your Honours, they're making it up as they go along. The final example I'll give you of prosecution's confusion between Ptolemy, Guerrero and Milutinovic's alleged responsibility for propaganda can be seen in 162 of their brief. They cite, or beg your pardon, they state, quote, an example of psychological and propaganda activities of Guerrero's organ directed against the enemy population with a loudspeaker used in JEPA to broadcast messages from General Mladić calling on the JEPA population to leave the enclave, end quote. In fact, they erroneously cite P2588 for this proposition. It's a typographical error we accept because they must mean it's P2788. However, the document in question is a direction from Ptolemy to the Security Department of the 1st Krajina Corps. It refers to the involvement of Milutinovic's centre, the one I have referred to earlier, being involved in arranging with the JEPA loudspeaker. It has nothing whatsoever to do with General Guerrero. At 34086, the prosecution asserted in their closing arguments that Guerrero had the ability to disagree with Mladić whilst at the same time keep his job, and that this proves that Mladić trusted and valued Guerrero. The relationship between these two men is fully dealt with in our final brief at page 77 onwards. In fact, we suggest, at the very least, the evidence in this case gives rise to an inference that Mladić had little option but to retain the devil he knew, rather than the SDS lackey that Karadzic clearly wanted to put in his place for Guerrero's job, Doronic in particular. In support of this proposition, we invite you to look at Simic's evidence 28.
Thank you for slowing down.
Thank you. We rely on Simich's evidence, 28607, Skirbich 15562, and Dukic's 92 Kata statement 6D315. Two legal issues. The first is the mass murder, Your Honours. Madame Favreau has addressed the issue, and I'm going to do the same briefly. At various points of their final brief, the prosecution make a bare assertion that General Guevara had knowledge of the mass murder operation. For example, paragraph 477 of their brief. They cite no evidence whatsoever in support of such a startling conclusion. This unsubstantiated submission cannot be accorded any weight whatsoever and sheds no light at all on Guevara's knowledge or mens rea in respect of the crimes for which he's charged in the indictment. Other examples of the same can be found in paragraphs 1804 and 1809. Your Honours, in short, this sort of stuff is the worst sort of prejudice. It fills no legitimate purpose, but it's much worse than that. It is totally illegitimate. It's totally illegitimate because, as the prosecution well know, General Guevara is not charged with these allegations. They've chosen not to charge him with those allegations, and they are allegations, which I might add, and to state the obvious, that are about as serious as one could possibly imagine and find anywhere amongst criminal offences. Your Honours, since he was not charged with these allegations, the defence have at no stage in this trial sought to deal with them. That's what happens in criminal trials. The defence seek to defend those matters with which their client is charged. Nothing more and nothing less. Please bear that in mind. The last legal matter I wish to turn to is opportunistic killings. At 34174, Mr. Elderkin sought to deal with the defence submission in relation to paragraph 31.1a of the indictment. What emerged from his submissions, as we understand it, is that the prosecution are now saying that the alleged killings in question took place on the 13th of July as opposed to the pleaded date of the 12th of July. The simple point is, and it's quite clear from the Guevara brief, that the issue that the defence addressed, both in evidence and in the brief, was the case as indicted, namely the 12th of July. We contend that it's both unfair and impermissible for the prosecution to seek to change their case in this way in their closing arguments. They didn't even do it in their final brief. And we rely in support of that proposition the case of Kunarach, judgment 4th of November 1999, paragraphs 16 and 17. More generally, on opportunistic killings, I'd like to make some submissions about foreseeability. The indictment alleges that the killings were a natural and foreseeable consequence of the JCE to forcibly transfer the population of Srebrenica. The prosecution has pleaded no material fact in support of this allegation, merely providing details of the killing themselves. The defence, we contend, has had no indication of what information should have placed our client and his lawyers on notice that killings were a, quote, natural and foreseeable consequence, end quote, of the displacement. On this basis alone, counts 4 and 5 should be dismissed, as the material facts essential to this allegation have simply not been pleaded. Moreover, we contend, no evidence has been adduced during the course of this lengthy trial to indicate that the executions in question were a natural and foreseeable consequence of the evacuation of the civilian population from Srebrenica. The killings were entirely unconnected with the evacuation, and in fact actually were or may have formed part of the JCE to mass murder the able-bodied men from Srebrenica. The burden in that regard, of course, being on the prosecution. As explained in the defence final briefs at pages 35 to 37, the prosecution are required to prove beyond reasonable doubt that each of the separate allegations of opportunistic killing did not form part of the mass killings. At 34178, the prosecution in their submissions asserted that the executions charged as opportunistic killings in paragraph 31 of the indictment were either, quote, spontaneous acts of violence or targeted revenge, end quote, which, quote, took place at locations other than the chosen execution sites and for reasons other than military orders, end quote. He said that it's this, quote, opportunistic and foreseeable, end quote, character, which distinguishes them from the, quote, vast and organised mass killings, end quote, which were not foreseeable as a consequence of the forcible removal JCE. We contend that this submission holds no water in the light of paragraph 30.2 of the indictment, which relates to the summary executions of 16 men by a small squad of soldiers on an isolated bank of the Yadar River on the 13th of July 1995. That allegation is plainly the same tenor as those alleged in paragraph 31 in the indictment, and only indicates the sameness of the mass killing operation and the killings alleged to have been carried out opportunistically by the prosecution. Even more importantly, we contend, for our client's case, there is a complete lack of evidence indicating that General Guevara willingly accepted the risk of opportunistic killings taking place. His Honour Judge Kwan asked this very question to Mr. McCloskey last Friday at 34284. We suggest that my learned friend Mr. McCloskey was simply unable to point to any evidence to indicate Guevara's adoption of the risk at all. The dearth of evidence on this issue was such that he was forced to rhetoric about the ugliness of ethnic cleansing in wars and that VRS soldiers were going to act out against Muslims in the light of ethnic cleansing of Serbs from Grahovo and Glamoch. As discussed in relation to the foreseeability limb of the mens rea requirement for JCE3, a general knowledge of a desire for revenge by some VRS soldiers, or the possibility of war crimes being committed during a war, is manifestly insufficient to show a willingness to accept the risk of opportunistic killings. Mr. McCloskey then purported to rely...
Thank you for slowing down, please.
3. That's 2753, the document issued by General Guevara on the 10th of July, entitled the Muslim war trump card. He said this in some way indicates Guevaro's acceptance of the risk of opportunistic killings following on from the evacuation of the civilian population. Given that the evacuation operation had not yet taken place at the time that P2753 had been written, it's hard to see how this document could possibly indicate General Guevaro's mens rea for the opportunistic killings for the purposes of JCE3. We contend that the prosecution case on these killings is, to put it plainly, unsustainable. Your Honours, there's one final part of my address. I think it'll take about 15 minutes. I'll certainly be finished well before the end of the day. I think I need to request 5 or 10 minutes extra time, therefore.
Absolutely no problem about it.
Thank you.
Mr. Haynes, that would basically leave us with a few minutes before we are due to adjourn. I suppose you would prefer to start on Monday, won't you?
I would have started with anything up to 15 minutes left of the day, but
There won't be 15 minutes.
no. Thank you very much.
Thank you. Mr. Joss.
Yes. Wish to turn to the issue of sentence, Your Honour. From the defence's point of view, the decision by this institution to roll the conviction and sentence stage into one is unfortunate in the extreme. There are a number of difficulties and downsides in this, and you'll be glad to know I'm not going to go into them all today. But from a defence advocate's point of view, it places him or her in an invidious position. Throughout the trial, in this case, as we all know, in excess of 3 years, the lawyer has been proclaiming from the rooftops the innocence of his or her client. And then right at the end of the procedure, the lawyer has to say, well, hang on a minute, Your Honours. If you happen to find my client guilty, then you might want to hear the following and bear it in mind when you come to sentence him. This, as I've already said, is highly unsatisfactory from the lawyer's point of view, but also from an accused. But in fact, it goes further than this, because in reality, it makes it impossible for counsel to comment and mitigate on the exact basis on which his or her client has been convicted. By this I mean as follows. If the procedure was, as we say it should be, judgment on conviction first, then this would allow an accused and his or her lawyers to know which counts the accused has been convicted of. And also, in a judge-only system such as is operative here, the accused would know the basis on which he's being convicted, the degree of culpability, because that would all be set down in the judgment. This would in turn allow the defence advocate to address all these issues in mitigation prior to sentencing. Well, obviously, I cannot do that on behalf of General Guevara. The best I can do in this regard is to urge you that in the event of a conviction on any of the counts of this indictment, is for you, before you come to pass sentence, to really place yourself in the position that I'm in today and ask yourselves, what would the defence be submitting at this juncture as to the nature of the conviction, the degree of culpability, and what can be said on behalf of the accused in that regard. In relation to those matters that I can say at this junction, everything I say in the next few minutes needs to be considered in the context that Mr. Kurgovich and I, on behalf of General Guerrero, do not resile from the position we have advocated throughout this trial, namely that our client is not guilty and the proper verdicts you should return in relation to all counts on this indictment is precisely that, not guilty. We say the prosecution have not proved his guilt beyond a reasonable doubt. Addressing the issue as best I can, first and foremost, we contend that the prosecution final brief's sentencing recommendation, so far as General Guerrero is concerned, bears no relationship to reality. So far as General Guerrero is concerned, deliberately or otherwise, it continuously falls into the same trap. The very first paragraph, 2806, says, quote, over 7,000 people were systematically murdered, end quote. Now, without being blasé about this important topic, and whether this is true or not, there is no doubt that a terrible crime of mass murder was committed. There's also no doubt that Milan Guerrero is not charged with this crime and is obviously not going to be punished for it at all. If the tarring of Milan Guerrero with the brush of mass murder in the context of sentencing is a mistake by the prosecution, it's careless and unfortunate in the extreme. If it's deliberate, it's nothing short of disgraceful. As for the recommendation, as I've already contended, it bears no relationship to reality. It is acknowledged by many commentators that sentencing at the ICTY is rather too much of an imprecise science. Now, there may be good reasons for this, but when it comes to Srebrenica-related offences, consistency, we suggest, is both possible and desirable because of the number of accused who've already been sentenced for their roles in these events. In this regard, we would invite your honours to examine certain passages from the very last judgment in relation to these events, namely the appeals chamber judgment of Blagojevich and Jokic on the 9th of May of 2007. The topic as a whole is dealt with in paragraphs 319 to 346. In paragraph 332, the appeals chamber described the prosecution's assertion that Blagojevich's sentence was inadequate compared to Krstić, Momir Nikolic, and that of Obrenović. It's worth remembering that it was there that the prosecution were arguing strongly for consistency and comparison. That's what they were urging on the appeals chamber. Now, it's true to say that at paragraph 333, the appeals chamber sets out the limited value of comparing sentences at this tribunal. However, we contend that in paragraph 334, in reality, the appeals chamber do just that and do compare the sentences, because obviously the crime base is either the same or ostensibly the same, but the actual role of each of the accused in the crimes was different. And for example, at the very end of that paragraph, the appeals chamber says, and I quote, Blagojevich's criminal liability is also distinguishable because, unlike Momir Nikolic and Dragan Obrenović, Blagojevic was not convicted of participating in the mass killing operation. The position and analysis, we contend, is similar at paragraph 345 so far as Jokic is concerned. It's clear from what I have just read out that comparing Srebrenica offenders is of validity. Now, of course, at the same time, that a trial chamber in passing sentence must consider the role of the accused in question carefully and in detail. What we say is this, that there are 3 accused, particularly, all of whom have been convicted after trials at this institution, whose sentences you should pay close regard to. The first is Krstić's. He was convicted inter alia of genocide and ultimately received 35 years in prison. Blagojevic was convicted inter alia of aiding and abetting genocide, 15 years imprisonment. And Jokic was convicted inter alia of extermination, 9 years imprisonment. These offences are, whichever way one looks at it, far more serious than the offences for which Milan Guerrero is charged and stands to be convicted, even in the worst eventuality on this particular indictment. Bearing this in mind, for the prosecution to suggest that Milan Guerrero, even taking the prosecution case at its highest, that he should receive a sentence of life imprisonment with a 30-year minimum term is nothing short of absurd. The reality is, and I make no apology for saying this, that the prosecution's submissions as to sentence are of no help to you whatsoever when you come to determine sentence in this case. Now, Your Honour, there are a few matters in mitigation which I wish to point to. Interestingly, the evidence in mitigation that I rely upon has basically emerged organically during this trial, inadvertently, really when the court's been dealing with other topics or witnesses have. And I'm going to run through this very quickly simply by pointing some page numbers. The first point is we'd invite you to look at page 75, paragraph 135, and page 116, paragraph 53 of our final brief in relation to Azim Hodic. Secondly, we'd ask you to look at page 115 to 117, paragraphs 50 to 54, which is material basically addressing the indictment, but it contains some material that you may find useful in relation to mitigation. Third, we'd invite you to look at General Simic's reference to the Batkovich camp, which were, you may think, entirely unprompted, on the 21st of November of last year at 28601. Fourth, page 91, paragraph 11 of our brief in relation to the document P28 issued by General Guerrero. In relation to the correctness of this document, see the reliance placed on it by the prosecution in their closing arguments at 34138 on the 3rd of September. And finally, General Guerrero's distribution of various ICRC documents in Serbian to his troops, described in the evidence of Skrbic at 156. I'll give that again. 15569 to 15572. Next, voluntary surrender. It's not clear in the prosecution brief at paragraph 2831 if they actually concede that that is what General Guerrero did. But Your Honours know from the various provisional relief applications in this case and also the decisions that you have made, that it's not been in dispute. It can be said that General Guevara voluntarily surrendered, and I urge that as a piece of mitigation on his behalf. Next, his health. Now, Milan Guevara is not only the oldest man on trial in this case, he is now the oldest person in detention at the UNDU. As you know, he suffers from relatively poor health. You know about all this from the various reports that you have seen in our various provisional release applications. In particular, you know that he will shortly require open heart surgery. The fact that health is an issue that a chamber can take into account in terms of sentencing was dealt with in the Strugar appeals judgment of the 17th of July of 2008, where that court said, after examining the relevant evidence, the appeals chamber considers that Strugar's deteriorating health since the trial judgment was rendered must be considered as a mitigating factor. Your Honour, in conclusion, and without wanting to labour an obvious, sombre, but above all else important point, we can only urge you on behalf of Milan Guevara that in the event you convict him on any count in this indictment, that you pass a sentence that does not inevitably mean that he will die in prison. Thank you.
Thank you, Mr. Josh. Are there any questions, Judge? Do you have any questions? Not at the moment, anyway, but we might have Monday. I don't know. So we stand. Yes, Mr. McCloskey.
Just to clarify the record, we agree that Milan Guevara and General Milicic self-surrendered.
Okay, thank you for that.
Thank you very much for that. Obviously, we're grateful from this side of the court.
All right, thank you. So we'll reconvene Monday morning at 9. On Monday, Mr. Haynes, I assume, would finish within the 2.5 hours allotted or allocated. Do you intend to ask for time for a rebuttal or not?
Mr. President, my intention right now is to ask for 15 to 20 minutes of rebuttal, specifically to answer some of the factual allegations made by the Borovchanin defense. For any of the other cases, I don't see anything right now.
Okay, thank you. We stand adjourned Monday, 9 o'clock. Thank you.
All rise for your full